News regarding Canadian immigration about the children who were born in Canada, but they remain overseas, they remain abroad for 3 years, and they were not able to get their human rights, they were not able to get the Canadian citizenship, according to 2009 law, which proved unconstitutional by the Federal Court of the Canada. Now, currently, another bill, C-71 bill, was going to be passed in the future, and some opposition to this bill is that. But this bill states that these children who were born in Canada and they remain 3 years outside, they must be given Canadian citizenship automatically because they were by birth in Canada. And if there is any possibility, if they stayed in Canada for 3 years, they also may be given Canadian citizenship automatically without application. So this bill, a lot of oppositions are there also. So this bill will be passed or not passed. That is the future discussion. But the Canadian Immigration Department extended the application of the citizenship for such affected individual from August to September, because they are watching about the bill. Canadian Immigration Minister is also very active, and if this bill is not passed, which is looking currently, because oppositions are telling that we are not going to pass this bill from the Parliament House. If this bill is passed, then it means these children will get the citizenship automatically. If this bill will not be passed, the immigration minister, may use his rights and may provide a digital facility to such individual, to such affected individual. Until now, there is no exact number of these affected individuals. These individuals will apply online due to special digital app and digital software, separate digital software. They will be able to apply for citizenship certificate with their requirements, and they will fulfill their documents, they will submit their documents, and then Canadian government and IRCC may give them the citizenship certificate or the citizenship. So this is good news. The C-71 bill, we all children who are born in Canada and remain overseas, and they just looking C-71 bill. Even these are not the children, because time is past now, they are elders as well. They are more than even 17 years, most of the individuals, and they are just watching what's about the fate of C-71 bill. If the C-71 bill is passed, it means these people will get the nationality, the citizenship of the Canada automatically without application. And a lot of people, but this federal court decision, that 2009 decision about such individual, was unconstitutional, in which it was clearly written that they must follow rules of Canada, they must stay in Canada 5 to 7 years like students, like work permit holders, and they have to provide services to Canadian government, Canadian companies, the Canadian society. They have to submit taxes. If they will not able to fulfill these nationality requirement, they will not be able to get the Canadian citizenship card. It means that under 2009 law was that these children, these individuals who by birth were in Canada, they must be given same platform as students, work permit holders, and there will be equality between them, and they must show their proof that they are living in Canada and they are providing services through the work permits, and same very complicated procedure for getting permanent residency. But under 2009 law, when it was challenged to the federal court, now currently the federal court clearly told it is quite unconstitutional. When person is by birth is here, he has complete right to get the Canadian citizen, even he or she is not living here. I will explain what is the actual scenario. When children by birth is there, parents move from Canada to other countries. Actually, parents may be Canadian or may not be Canadian, but the children who are by birth Canadian now, because they were born in Canada, even their parents were students, if they will move out of the Canada for 3 years, 4 years, when they will move back to Canada under 2009 law, they were not eligible to get the citizenship. And this is the actually problem. But human welfare organizations and some people did case to the federal court and told it's quite humanitarian. That humanitarian reason is that because these kids were born in Canada, and this is the rule of almost all countries. When by birth individual is they are writing that our birth is in Canada, so why we are not giving Canadian citizenship to such individuals? Even they were outside, their birth was in this country. Therefore, there must be little rule to give them little bit age. Of course, they must be given opportunity to apply for citizenship, but they must not be treated like students. They must not be treated like work permit holders because they were by birth in Canada. So that was the actual fate of 2009 law opposition. And federal court accepted this writ and petition and told yes, this look very awkward that the persons who are born in Canada and they are not giving preference, they must be given preference over Canadian other work permit holders, other visa holders, tourist visa holders, student visa holders, the work permit holders, and they must be given a special route to get the Canadian citizenship, and they must be given a special path to get the Canadian PR, Canadian citizen. Actually, Canadian Department of Immigration, IRCC, is lacking number of the PRs which they had to issue in 2024, 2025 and 2026. They have already announced the numbers of the PR. Now when Supreme Court or Federal Court announced this additional PR, additional citizenship cards, so definitely they will sacrifice from those numbers. Already they are thinking that the individuals who are currently in Canada or who will come to Canada as a work permit holder, as a student visa holders, their numbers are more and the number of the PR are less. Now consultants are straightforward telling that PR chances are less, and Canadian government is clearly giving message to the students that you may be given work permit and you may be given 4 year 5 years work permit, and we appreciate your services in Canada, but it's not guarantee that we will give you PR, because PR numbers in 2024, 2025, 2026 we accepted, allocated a very less number of the permanent resident. So that was a little bit a position by Immigration Department, that how we don't know what are actual exact numbers of these affected individuals who were born in Canada and living overseas, and they would be eligible for Canadian citizenship by this C-71 law. If C-71 law is approved, there will be no complications of applications of nationality or citizenship. Automatically they will get a PR. So this will IRCC, the data which they have issued, the number of PRs they have issued automatically will decrease. Therefore IRCC is doing a position, and they told that we are not able to give PR to all individuals. We will give the PR to some affected individuals, and we are planning that Immigration Minister announces some portal, and Immigration Minister may do press conference in the coming days, and we will give them special permission to apply for citizenship. We will assess the application. If they will be suitable, we will give them PR. But I think C-71 bill is a very powerful 50-50 chance in Parliament House because some people are speaking in favor of those individuals. Some human welfare organizations are speaking, especially they are giving reference of federal judges, because they clearly wrote that 2000 law was unconstitutional. So for further detail, keep watching World Immigration News by Irfan. Hopefully you will subscribe, like and share my channel. My email is written in description. You can email me for further queries and for further immigration problems. Thank you very much.